we've got a good number of folks. We're going to go ahead and get started for time's sake. Thank you for being here. I'm John Smith with the Board of Directors for CCRA, and certainly excited about this. Is our third time we have held this class. We met the first time as a live class, 53 agents joined, and then our second class we had over 300 agents, and today we've got about 140. So we're reaching about 500 agents, a little over 500 agents, and that's exciting to know that that many agents are involved and want to learn more about the contract. Of course, our goal is to create a contract, an association where agents cooperate well with each other because they know the contract, and that's one of our goals of doing this contract class. So I'm joined today by Matt Carroll. Matt is our chair of our 2020 contract committee. Gary Pickering is our legal advisor. Everyone knows Gary. Gary's very involved with the association. And Becky Ashby is going to join us. She's having some issues this morning, technical issues with her computer. So as soon as she can get that worked out, she'll be joining us. Becky is a new member next year of our board of directors and also vice chair of our contract committee. Both she and Matt have done an excellent job way back to 2016 when the contract was put together. So we appreciate their efforts there. So let me just go over a couple housekeeping things quickly. I know Gary likes to move along, so let me go through this real quickly. It would be helpful if you had a copy of the contract in front of you. I try to teach our agents to use a highlighter and highlight those areas that are aha moments for you, maybe things that you've learned today. I learn something every time I look at the contract and go through this class, so hopefully you will too. Also, as a advertisement, we have done about 4 videos where we've actually broken down the contract into smaller bites. Paragraph 8, where it talks about the buyer right to inspect and re-inspect. Paragraph 9 and 10, where it talks about the timelines of the inspection. And paragraph 11, where it talks about the condition of the property. And then paragraph 16, where it goes into the contingency, how to use the sale and closing contingency and the closing contingency, and paragraphs 29 and 27, where it talks about defining the business day, paragraph 29. And so we invite you to look at those videos. They're about 10 or 15-minute videos. They're on our CCRA website. They're also on our Facebook page. Those are great videos to look at if you want, as broker in charge, if you want to teach a class, if you want to teach your agents, newer agents, and also as a review for some of our more experienced agents. So anyhow, the class today is about 2 hours long. We will give you an opportunity to ask questions. If you have questions for Matt or Becky or Gary, certainly use the chat button below to the chat or the Q&A button. Becky and Matt will be trying to answer your questions. If there's a question that comes up you feel like, or we feel like Gary needs to address, we will interrupt Gary in his presentation asking those questions. We'll also have some poll questions that we're going to put up from time to time. We'll give you about 30 seconds to answer those questions. These are pertaining to different paragraphs in the contract that we have found to be a little bit problematic or areas where agents might struggle a little bit. We'll put those poll questions up, give you a chance to answer them, and then we'll give you the correct answer, and then Gary will continue to move on. So again, we will be done today about 11 o'clock. It's a 2-hour class, no breaks. But Matt and Becky and Gary have agreed to stay on a little longer after our recorded class and answer any additional questions or scenarios you have. So anyhow, thank you for being here. I think Becky's on now, so we've got a full panel. And Gary, again, Matt, Becky, thank you guys for doing what you do with the contract. We appreciate it. And Gary, I'll give it to you.
Don't you have a poll question you wanted to do first, John?
Yeah, let me put up, Kathleen, why don't we start by doing that? We have 3 poll questions. These are real simple. These have nothing to do with the contract per se, but they do give us information on what experience the agents might have, how often you use the contract, and are you using the lot and acreage contract as well as the residential. So Kathleen, if you'll just put the first 3 questions up, give them about 20 seconds on each question. They're real easy to answer, and that'll give us an introduction to our audience, and then we will jump right into the contract. So I'm trying to vote, it won't let me vote. We are restricted as panelists. Okay, question number 2. There's our results from number 1. So we've got most of our agents here have been in the business 5 years or longer. Welcome some of the new agents to our contract class. If you're brand new, we're glad you're here. This is, I think, one of the best classes that we teach. How often do you use the contract? I know some of you occasionally will use a state contract, or as a seller's agent, you will see the state contract. Okay, and we'll see the results of that poll as well. So 75% of you use exclusively, so fantastic. We appreciate that. And then our last question, our introduction question, has to do with the lots and acreage contract. The contract committee is always trying to improve the contracts and some of our forms. We don't change the contract every year just for logistical purposes, but I think if we have enough interest in making some changes, then the contract committee would consider that and do that quickly. And so we've got almost 25% of you have never used it. So that is available. It's very similar to the residential contract in terms of verbiage. So encourage your use on that. So again, thank you for being here. Everyone, Gary, again, thank you, and we'll get started.
All right, thanks guys for having me today. Thanks for CCRA. If you've ever wondered why you're a member of the Realtors Association, this right here, in my opinion, is your number one reason. I know the association does a lot of things for you, but this is one of the main things that they have really spent a lot of time on, which is providing educational tools for you, particularly during the COVID crisis. This is a prime example of them stepping up and providing you information during the COVID. I know we've had, 5 or 6 different classes and relating to COVID and things like that. So Kim and Taylor are doing an outstanding job. Kathleen is keeping everybody where we need to be. So thank you to CCRA. I would also be remiss if I didn't mention RPAC. Please, if you are not donating to RPAC, we need you to donate to RPAC. This COVID virus shows you how important RPAC was, because it was the work of your associations that got you declared essential. And if it was not for the work of the associations working with Governor McMaster to get you declared essential, we could have all been shut down in March, April, and May and not made any money. So that's a prime example right there of why everybody needs to be part of RPAC. All right, well, going to our contract, I'm going to go ahead and share the screen real quick. So let me pull that up. So if you don't have a copy in front of you, you will be able to look here with us. And what we're doing is we're looking at the most recent version of the contract, I hope. But the contract, we started using it back in 2000. I think it was like 2008. I've been on that contract committee since the beginning when Dan Pater was trying to put together this contract, which is an idea that we had. And so I've been very blessed to be part of this contract and being part of being the attorney for the committee for, I think, about 12 or 13 years on this contract. So I think what we got here is a great contract. And what we're going to do now is just kind of roll through each provision, talk about issues you need to be aware of, some areas that kind of stand out with us as attorneys that we see that people struggle with. So let's go ahead and start up here at the top. The very first thing you'll see on the contract, right under the name contract of real estate for sale, is the buyer-seller's license under the law of the state of South Carolina. You are required in South Carolina to disclose your true position. And if you are a buyer or a seller of real estate and you're serving as a licensee on this transaction, you must disclose that by state law. Now, state law does go a little bit further than just requiring you to disclose if you are personally buying. It actually includes immediate family, or if you own any part of a business, a corporation, an LLC that is also buying it. As I tell people, the fact that you are an agent representing your cousin who is buying the property is never a reason that the seller will not sell the property to you until there's another issue. And then when there's another issue, when they file a grievance, then that all of a sudden becomes the biggest issue. That had you told them that your cousin was the buyer, they never would have agreed to sell you the property. Now, we all know that's not really the case, but that does become a claim in a lot of cases that I see before LLR. So be sure that when you are doing this contract, if you have any form of ownership or somebody in your immediate family, spouse, partner, child, parent, whatever, that you are disclosing that. I would check the box, and then in paragraph 18, list what that relationship is. Now, paragraph 1 should be very easy. It's our parties. It's not always filled out correctly with your buyers. Make sure with your buyers that you are giving us full names of the buyer. For instance, John Smith, who is here on our seminar with us. How many John Smiths are there here in Columbia, John? What, 50, 60?
37.
37. So 37 John Smiths. So if we are going to use, if John's going to be a buyer, when you have names like John Smith, Michael Jordan, it's very important to put that middle name. It does help the title abstractor to be able to eliminate potential liens or judgments that do not apply to that particular John Smith. So be sure to do that. Under sellers, what I would tell you that we see as mistakes as lawyers is we see sometimes owner of record. That is never a good idea. So you always want to make sure that you do at least a minimal amount of due diligence to figure out who the seller is. Go to the MLS and see who the listing agent is listed as the seller. I would strongly advise you to go on the county websites, richlandonline.com, lexington-co.com, and see what information they are showing as the seller, so that you are sure that you're getting the sellers. Oftentimes in South Carolina and other states, you'll see that one spouse will sign as the seller when in fact the other spouse may be the owner of the property. So in my situation, I think my house is titled in my wife's name, but if I was, my wife would probably tell you that if we were trying to sell the house, she'd just want me to deal with it because this is what I do every day. And so if you had me sign as the seller, you would not have a valid contract. So it's very important that you figure out by looking at at least minimally looking at the records at the tax assessor's office to make sure that the person signing is in fact the owner. And the same thing goes, sometimes you'll see one spouse will sign or one partner will sign when in fact you need both signatures. The other aspect of sellers that we're seeing a lot of problems with is that Gary Pickering Properties is not anything, but Gary Pickering Properties LLC could be a valid company. And so when we have companies that are selling properties, a lot of parties, a lot of agents will just write the company's name and we'll not put the designation of the LLC or the Inc. or the partnership or whatever. So you need to make sure that you're doing that. An easy way to make sure that you are getting the proper name for the seller when it is a company is simply going to the South Carolina Secretary of State's website, which is scsos.com, and then just search for company and type the name in and you'll find the legal name of the company. If we're not using the correct legal name, then you may not have a valid contract. So be sure that you are getting those names correctly. This is also a good time when you are meeting with a seller and that seller is a company or a partnership or a LLC, that you are asking to go ahead and get papers from them showing them who has the authority to sign for the company. So you want to go ahead and ask them because the lawyer is going to require it, the lender is going to require it. So go ahead and ask for the operating agreement. On the operating agreement, it should tell you the actual correct legal name, and you can be able to do that there. The other thing I would tell you before we move off of parties is when you're dealing with a church, please pick up the phone and call the closing attorney because churches are very difficult to get their actual correct name. Some of them are set up as nonprofits. Some of them are set up as corporations. There are variations of how that's to be done and who is to sign for the church. And so you really need to have some legal advice on that because sometimes the minister can sign, sometimes it's a member of the board, sometimes it's an appointed person in the congregation. So my suggestion is if you're dealing with a church as a buyer or a seller, go ahead and call the closing attorney and see what information you need so we can get the signatures correct on that. Now, paragraph 1, the second part of it, buyers and sellers acknowledge disclosure of the broker relationship form and client and customer service in the transaction, client or customer service. We had to change this after 2017. This was one of the changes we made in the most recent versions of this contract. The reason being is the 2017 law required this to be disclosed in the contract. And this is just an example of how the contract committee, we meet every year, pretty much once a month every year, and we look at things like this. So when there are changes in the law or changes in how the contract is being perceived or used, that we have to come in and make changes. And that was one of those changes that we made. All right, paragraph 2, property. This is where we need you to be very careful and make sure that you are completing as much of this information as possible. as a closing attorney will tell you, the worst information in here is the address. Lawyers do not use addresses. ROD does not use addresses. Addresses are for mailing and for 911. That's about the only use they have in real estate. What we're looking for when we're dealing with real estate is lot, block, phase, subdivision. That's the kind of things we're looking for. Tax map numbers also are helpful unless you're selling a portion of the property, and then it becomes something we also got to look at. So this is not an area just to fill in minimal information. This is where you need to fill in as much information as possible. Again, in Richland, you go into richlandonline.com and you can find out typically this information on that website, or lex-co.com and find it in Lexington. So provide us as much information as possible. You also want to make sure you understand exactly what you are selling with your seller, and you also need to make sure you understand exactly what you intend to buy with your buyer. I did handle a case a couple of years ago where we had two lots that were beside each other. The lot A had a house, lot B was just woods, and the lot B was not transferred in the transaction, only lot A when the house was. Lot B wound up going to a tax sale. Luckily, the person found the tax sale information and they were able to stop it. But the problem was when the agent filled in the contract, they just put lot A. They didn't put lot A and B. So when the closing attorney went to do the closing, and this, I think it's happened in Camden, when they went to do the closing, they followed the contract and transferred only lot A. So lot B never got transferred. Taxes were no longer getting paid on it. In that situation, the real estate agent had to come up and pay the back taxes and pay, I think the person, somebody had actually bought it at tax sale, so they actually had to reimburse the person at tax sale. So it wound up costing the real estate agent about $10,000 or $12,000. So be sure you know exactly what the seller is selling and what your buyer intends to buy, and make sure that you are completing this information. You would also think that the county of would be easy to get. Y'all are no longer just selling Richland or Lexington County. You're now selling Richland, Lexington, Kershaw, Fairfield, Saluda. You're even getting now into Calhoun counties and Orangeburg. And so as your geographical area expands, it's very important that you get the county correct, because when we send someone out to do the title search, it's all scheduled. And so if you tell us the county is in Lexington County, but it's in fact Calhoun County, we sent somebody to Lexington, it's just going to cause delays in getting your title work. And right now, when you're talking Calhoun County and some of these smaller counties, a lot of them are closed to the public, and a lot of their information is not online. So we have to schedule appointments for title abstractors to actually go out there to do the title abstract. And so if you give us the wrong county and we go to the wrong county, then it's just delays getting your title search done. Now, the other problem you have here with counties is some properties are in two counties. So if you're in like Friars Gate over in Irmo, some properties in there, the property line runs right through the middle of the property. And so in those situations where you don't know, put both counties for us so that we know that this is a property that might straddle the property line. All right, paragraph 3 is purchase price. Again, another section that should be easy. I don't know that we have this problem as much as we used to, but back in the day, we used to write the numbers out here, and then you would fax over the offer to a party. They would change the offer amount, counter offer, and send it back. And after about 5 or 6 different faxes of the same contract back and forth, no one could read what the numbers were anymore. And so just be careful that when you're doing counter offers and offers, most of y'all are using some type of zip forms or some type of platform. Go in and change that price so that it's clear that no one is questioning what the price is and which one's the final price. I've also had a situation where someone hand wrote the contract, and their handwriting was so poor that the lender, the buyer, the seller, and the attorneys all thought the price of the house was a different price when we got to closing. Their number could have been a 0, a 9, or a 6, and nobody really knew what the number was, and everybody thought it was something different. And so at closing, we're arguing over what the price of the house was. And if I'm not mistaken, in that one, the agent wound up having to put money in the transaction to get it to close, because the buyer and sellers had a different view as to what the price was. So be sure that it's clearly written what your numbers are here, and that you're scratching out, and so there's no doubt whatever the counter offer is. All right, paragraph 4 is earnest money. Earnest money is now just an unmitigated disaster for us.
Gary,
yes, sir.
Let me interrupt you. I'm just curious, now that we're at earnest money, can I just throw a poll question up? I want to see how many brokerages are actually holding earnest money. I know you'll get into this a little bit. So Kathleen, if you'll put up our poll question, and ask our audience who actually still holds earnest money as a brokerage.
And y'all see the poll question, I hope.
Okay, thank you. Let's see how many are actually holding that. Okay, so about 83% do no longer hold it, and some of the brokers still do. So that's an interesting. Thank you.
All right, if you'll let me screen share again, Catherine, or Kathleen, I'm sorry. I got a Catherine that works for me. All right, screen share again. So earnest money has become a disaster basically because the real estate commission screwed it up. I tried the case over there where earnest money had been released by a broker without a signed release, because under the state law it says that in order to release earnest money, you have to have a signed release, a court order, mediation, or interpleader, unless there's no other reasonable interpretation in the contract. And one thing that the contract committee did very well when we put this contract together was that we put in the contract instructions as to who was to get earnest money when certain things happen. And in this situation, particular situation, the buyer properly canceled during due diligence, but nobody would sign a release. I think the seller just disappeared off the face of the earth. And so what they wind up doing is the broker just released the earnest money back. Now, the commission ruled that earnest money could never be released without a court order or mediation or signed release, which is not true, because the actual law says, unless there's no other reasonable interpretation, the commission said they weren't in the business of interpreting the contract, which I told them they were, because that's what the law says. Nevertheless, we lost that case, which I told them at the time was going to cause a tremendous problem, which was going to be that the real estate agents would no longer hold earnest money, and then that was going to get pushed over to the attorneys, which was going to create a ton of problems for the real estate agent, which I'm already starting to see. So what y'all need to understand is, as I can see, we saw 87% of y'all are not holding earnest money. And so it does create issues for you. The number one issue that's been created for you guys right now that we're seeing a lot of is contracts are being signed saying that Blair Cato is holding earnest money. But your client has not sent us earnest money when you have presented that contract. So you're telling them that Blair Cato is holding earnest money when in fact you haven't even sent the money to us. Then the contract gets signed, life happens, coronavirus happens, people forget to send the earnest money. After a couple of weeks, your client defaults and the seller says, well, I want the earnest money. Earnest money was never delivered to Blair Cato because we never knew we were supposed to get it. And so it's causing a problem in this contract for a lot of you. So what happens here under paragraph 4, under section A, you're supposed to write the earnest money and how it's being paid, check, cash, or other. A lot of us have gone, or at least our firm has gone to an electronics means of being able to deposit earnest money. So if you're using our Zocum, you would just check other and put electronic wire or other. Under letter B is where you put additional earnest money to be delivered on or before. So what I have told a lot of agents to consider, I'm not telling you how to do this, but I'm telling you to consider this, is that if you are submitting a contract today, but earnest money is not being held by your company, so when the contract is ratified is when you're going to have your client give the earnest money to the closing attorney. I believe the proper way would be to, under letter A, write zero earnest is being paid, money is being paid today, because there is no earnest money at this point. And then under additional earnest money, put the amount of the earnest money that will be paid, and then put delivered on or before, put the time frame when it will be delivered, within 24 hours of ratification or something of that nature. And that way your contract is correct. And the other party knows that earnest money has not been submitted with the contract. It will be submitted only upon ratification. So I think that is the way that y'all need to be doing doing this to stay out of trouble with LLR. The other thing that's something to consider is that with earnest money, we're not getting enough earnest money, period. Under default, we do have there are some default provisions, which we'll get into in a little while. But when I talk to agents, I always talk to them about reality and legalities. And, if a party is in default, they may have a legal right to hold them in default and sue them for those damages. But the reality of it is, for the seller, oftentimes the only true recourse is going to be retention of earnest money. So if I was selling my house to Becky for $150,000 and the day before closing, she defaults for no reason whatsoever, and I wound up putting the house back on the market. In this market, more than likely, Matt's going to buy the house at $150 anyway. So I don't have a damage there. My damage is really only going to be my carrying cost for maybe the additional 30 months that I had to wait, or 30 days I had to wait to sell it again. And so my damages are minimal. So there's just not much chance of going to sue somebody over that. So your best recourse is probably keeping the earnest money. So I think in our industry, we need to really consider earnest money. You know, are we holding enough earnest money? $200, $500, is that truly enough money that if the seller is damaged because of a buyer default, is that going to be adequate to satisfy the seller? It seems to me that earnest money just becomes kind of an afterthought. Just write a number down. Remember, as a buyer, earnest money shows how strong your offer is. So in today's market, when we are trying to beat other people in offers, we're in a multiple offer situation, earnest money could be one of the things that the seller looks at and says, wow, this person's putting down $10,000 while this person's only putting down $100. So those are things that you need to look at. So be very careful with earnest money. The other thing I would suggest with earnest money before we move on is that with earnest money, what we're also seeing is that it's very difficult to get earnest money back in a lot of cases, because we now know that the commission has said you cannot release earnest money without a signed release or a court order, essentially. So sellers can really just refuse to release the earnest money back to the buyer for no reason whatsoever. I'm seeing more and more of this, that while we are in due diligence, that a buyer decides under due diligence that they don't want to buy the property. And what happens is the seller says, well, I'm just not giving their earnest money back, even though the buyer is clearly entitled to it. So the only recourse the buyer has at that time is to take them to court to sue them for return of earnest money, which is time consuming. The sellers know that. So they're basically trying to squeeze the buyer for a little bit of the money. So what I have seen some agents start doing is that they're putting zero earnest money down, additional earnest money to be delivered upon completion of due diligence. So that's something to consider. I'm not telling you that that's the best strategy in all cases. That is just one strategy that you could implement. All right, paragraph.
I have one question. Can I interrupt real quick, Gary?
Absolutely.
You mentioned the number 10,000 as just a random number for earnest money. But what happens if there's a dispute and the earnest money is $10,000 or more? Does that make more?
So if the money's over $7,500, you have to go to circuit court. If it's under $7,500 or less, then you can go to magistrate court. So it does put a higher level on what you have to do to try to sue to get the money back. Obviously, with magistrate court, you don't typically have to have a lawyer. You can handle the matter yourself. When you file an action over there, you can usually get a court hearing within a month or two. When you're at $10,000 or more, or $7,500 or more, you're going to wind up going to circuit court, and you're going to go in. Real court. Then you're typically going to have a lawyer, and you're going to be 12 to 18 months before you get on the roster. So that is a good point. Something to consider too when you're trying to decide how much earnest money that you want to put down. All right, letter D is the section that talks about escrow, and here is the section that I think a lot of us gloss over, but we really need to be telling our clients this information up front so that your clients do not get mad at you when there is an earnest money dispute. Go ahead and tell them when you're going over the contract here that when earnest money is deposited, if a dispute arises between the buyers and the sellers, that we cannot release the money unless there's been a signed release, court order, or otherwise. So I think if we spend a little bit of time talking about this section right here with our consumer up front and set that expectation that, hey, you may put the earnest money down, you may be entitled to it, but you have to understand that if there's a dispute between the buyer and the seller, there's nothing that your company or the attorney can do until a signed release is done or a court directs the order. Now, the other thing to understand in here is another tool here that the committee put together, which I thought was excellent. We actually didn't have this in the first version of the contract, but we went back and added it in the second version of this contract, is that if the seller or buyer wrongfully refuses to release earnest money, let's say it's very clear in the contract who's supposed to get the earnest money, a buyer cancels during due diligence or whatever. If they wrongfully refuse to release the earnest money, then the non-prevailing party in the court action can be held responsible for that attorney's for the attorney fees and court costs of not only just that person, but as also the escrow agent. So if John wrongfully refuses release the money, and Blair Cato is holding it, and Matt takes him to court over it, Matt's attorney fees could be paid, his court costs could be paid, as well as Blair Cato's costs to be involved in that transaction. So that could get very expensive for John, because as y'all know, lawyers aren't cheap. And particularly when you put two lawyers together, they get very expensive. The last part of that, which we added, the court may also award the prevailing party treble damages. And what treble damages means is 3 times the actual amount of the earnest money. So if we have $2,000 in earnest money, and it's a dispute, and John had no reason to refuse to release the earnest money, and the court could decide to take that $2,000 and make it $6,000. So that is something, when your client is acting unreasonable, that you can turn to the client and say, look, it's whatever you want to do, because you're the client and you make the decisions, but you need to understand your risk is paying paying Matt's attorney fees, paying Gary's attorney fees as the escrow agent, as well as paying treble damages, which is 3 times the amount of earnest money. So that $2,000 might wind up costing you 7 or 8. So that's a tool to use to hopefully convince your client to do what they should be doing. Moving on to page 2, we're talking about transaction costs. We changed this in the 2006 contract. Before this, back to the contract we had used previously, we broke down closing costs as the seller would pay blank closing costs, blank prepaid items, and blank discount points. And what was happening was that people were going in wanting $1,000 to be paid to any of the 3. They didn't care. So they would put 1,000, 1,000, and 1,000. And so it looked like the seller was paying $3,000 in closing costs. Our position on the contract committee is, what do you really care? You're just really looking for the money. So it doesn't really matter to you whether it's being paid for which one of the 3. And the seller doesn't really care either, because the seller's already agreed to pay $1,000. He doesn't care whether it's going to closing costs or discount points. So let's more broadly define what a transaction cost is. And as you can see in paragraph 5, it's basically it includes but not limited to all closing costs, prepaid items. It covers everything, and discount points. So it's basically everything. And so we put all that information in there, including costs to get to HOAs, interest, title fees, allowable costs from VA and FHA, deed recording fees, and costs of inspections, appraisals, surveys. And so we broadly defined that as broad as we could on purpose, so that it would cover as many things as necessary. Now, seller closing costs were defined as deed preparation, deed stamps, and all costs to deliver marketable title, payoffs, satisfaction, and so forth. It's very important to understand this section right here, particularly if you're not always working in our market, that our contract sets out that deed stamps are being paid by the seller. If you are working in a different market, be very careful with the deed stamps. Some markets split them. I think it's Hilton Head, the buyer pays half and the seller pays half. There's some other markets where the buyer actually pays the deed stamps, not the seller. If you are working with a lot of builders now have in their contract provisions that say they do not pay the deed stamps, that the buyer pays them. Some of them will pay the deed stamps only if you use their preferred lender and attorney. So be very careful with deed stamps. Do not assume that deed stamps are always paid by the seller. And in the CCRA contract, that is the case, but that's not going to be in all cases. Now, under the second part of paragraph 5, section A and B, now we're getting into the section of who's going to pay for these closing costs. So under paragraph A, the parties can decide that the buyer is going to pay all the buyer transaction costs and the seller is going to pay all the seller transaction costs, but the seller also agrees that the buyer is going to pay for non-allowable costs if the financing type selected is either VA or FHA. Basically, right now, the only non-allowable cost I think most VA loans has is the termite letter, and I'm even seeing the termite letter being allowed to be paid in some VA loans now. So the non-allowable costs are very few and far in between at this point. But right here under letter A, the buyer's paying their costs, seller's paying theirs. Make sure that the boxes are properly initialed and properly dated. We have seen this section just left completely blank, so make sure that this is being completed. Under section B, this is where the buyer and the seller can decide that the transaction costs are going to be partly paid by the seller. And so our first sentence here, seller will pay buyer's transaction costs not to exceed blank amount. Now remember, transaction costs, as we defined it, are discount points, prepaids, cost to close a loan, basically all of this stuff. Which this amount they paid includes all the non-allowables first. So if it's a VA loan and we have a $100 termite letter and you've agreed to pay $1,000 in cost, it's not $1,000 in cost and the $100 VA or CL100, it's $1,000, which would include the $100 for that CL100. So that gets paid as part of that money. All right, after that, buyer's responsible for paying anything that goes above that amount. If the sellers agree to pay more than that's actually needed, then the excess goes back to the seller. I cannot stress this enough. Please, please pay very close attention to this next comment. I see this every single day. I think we have 20-something closings today, and I guarantee you on 2 or 3 of them, we will see this, where the contract will say that the seller is going to pay $3,000 in closing costs. And when the settlement statement is put together, closing costs will be capped at $2,500 or $2,600. Essentially what has happened is your buyer has basically just thrown away money, because how we do these things is if I'm buying the house for 200 grand and now I want you to pay 2,000 in closing costs, we essentially raise the price in most cases to $200 and $2,000 with you paying $2,000 in closing costs. So without you paying the $2,000 in closing costs, I could have got the house for $2 grand. I think everybody understands that. Well, what happens is I go and get a no-cost loan, zero closing costs, because they built the cost of the loan into the interest rate. So I don't have $2,000 in closing costs. Or your loan requires you to have 3% in the transaction or 5% in transaction, and the amount of you paying any closing costs means that I don't have that number in the transaction. And so the only way the loan works is instead of you paying $2,000 in closing costs, you can only pay like $600 because I need that other $1,400 to show that I have the 3 or 5% in the transaction. So before you just go and put a number here that sounds good, please have your client talk to their lender. I assume all of y'all are already having your clients get pre-approved prior to even showing them property, which I hope all of you are doing that. So if you're doing that, go ahead and have them talk with their lender and ask them what kind of loan program they're going to have and what they can expect in closing costs. I had a transaction last month where I think it was a $400,000 or $500,000 closing. I think it was $400,000 closing costs. So they asked for 3%. It was $400,000 loan, so they asked for 3% in closing costs. 3% was 12 grand. We had $12,000 in closing costs on this thing. It was ridiculous. So they wasted so much money. I think they capped the closing costs out at like $4,000 or $5,000. Even after they paid a discount point, it's still they didn't come close to using all that money, so they completely wasted it. What happens at closing is they turn to you and look at you like, why did you not catch that? And so they're typically mad at the real estate agent for not catching that.
Hey, Gary.
Yeah.
Gary, let me jump in here. So this comes up occasionally. What if one of the parties initials one of the boxes? Let's say in paragraph 5, they've agreed to pay all their transaction costs, or let's say in paragraph 5B, they've agreed to pay some closing costs, and only one party signs that paragraph, but both parties sign at the bottom of the page. Would that be enforceable?
So buyer in letter B initials, they want seller to pay $2,000 in closing costs, but seller never initials.
But they initial at the bottom of that page.
They initial the bottom down here of that page. All right. That's a very difficult question to answer. And the reason I tell you that is what I would tell you legally is it's a material term of the contract, in my opinion, that needs to be initialed and dated. And so it provides argument for the seller that there was no meetings of the mind, and therefore we don't have a contract. I caution in telling you that because if the seller acts in such a manner to lead the buyer to believe that they do have in fact have a contract, that they've in fact agreed to these terms, and the seller has taken detrimental steps that are detrimental to their position, meaning they have spent money and otherwise, then I think there could be an argument of detrimental reliance. But for your purposes as an agent, you are required not only by the Code of Ethics at the Realtors Association, but by state law to make sure that all sections are initialed and dated. So if you fail to make sure that the seller initialed and dated this section, you violated state law and you violated the Code of Ethics. If the consumer was to complain to you, your job would be to make it right and make sure that commission, that you're lowering your commission or whatever you necessarily need to do to get those closing costs paid. Because if you get a grievance filed against you at the commission or at the association, I'm not going to be able to get you out of that. You are going to get punished on that. So make sure that those are done. But I would tell you, in your legal mind, what you need to think of, if these signatures, initials aren't there, we may not have a legally binding contract. Okay? All right. Paragraph 6, financing. This is the provision where your client decides whether or not the contract is going to be contingent on financing. But I will tell you about financing. We've gotten a habit, in my opinion, of just automatically checking the box. When you're sitting here with somebody who is the CEO of a company making $1 million a year, and they're making their contract contingent on financing on a $400,000 house, It just doesn't seem to make a whole lot of sense. Remember, every contract you are submitting today, there's a very strong potential that there's going to be multiple offers, and price does not always win. It's not the determination for every single consumer. So what you have to understand is you're trying to present the best offer that your client wants you to present. So you need to sit down with your client and ask them, is this going to be contingent on financing or not? And don't just check the box. I mean, we just check the box all the time. We got to just quit checking the box that, yeah, it's always contingent on financing, because it doesn't always have to be. Obviously, first-time home buyers, scraping the money together, that needs to be contingent on financing. But when you're looking at somebody buying their fourth or fifth or sixth house, and these people already have they own a beach house, this is probably not a situation where they need to be contingent on financing. You're trying to present your client's best offer. Be sure to understand that and explain that to your consumer. You let your consumer decide whether they want to make the contract contingent or not. Now, this was an argument that we fought over. I think there was some bloodshed and probably some illegal holds in the wrestling matches we had over this. Buyers and sellers acknowledge that financing contingencies automatically expire 5 business days prior to, but not including the closing date set forth in paragraph 7. So when we put this contract together back in 2006, I think when we were arguing this section, might have been 2005 when we started arguing this section, there was a lot of arguments. You had buyer's agents who said, we don't know whether or not we qualify or the loan's going to go through until it disperses, because that's really when you have loan approval, is when it's dispersed. We have seen cases where you close loans and then the buyer has gone out and done something detrimental to their credit that's caused the loan not to disperse. They ask for funding numbers pretty much on every closing, because they're finishing this stuff up and looking at this stuff. So buyers are of the position that, hey, it's not our fault the lenders can't tell us until the last minute. Sellers, however, were arguing, selling agents, listing agents, that we've got to have some drop dead date here. We got sellers that are packing up houses and moving, and they need to know at some point whether or not we're going to be able to close. And so after a lot of arguing, fighting, fussing, and moaning and groaning about it, we decided to keep the automatic expiration of 5 business days prior to closing. So it's there. It's probably never going to go anywhere, because I think it's just strong enough opinions to keep it. So understand it. Now, the biggest mistake people have when they do this is they don't realize, or they don't pay attention, it's not calendar days, it's business days. So be careful that if you're closing on Friday, you're not just counting back 5 days and go, okay, Monday's 5 days, so it's Monday. First of all, we don't count the day of closing. So if it's Friday, we don't start counting backwards until Thursday, because it doesn't count the day of closing. So then you're counting back Thursday, and you're not counting weekends or holidays. So 5 business days goes back into the previous week. So you need to calendar this on all of your calendars when you are working with a consumer that has a contingent on financing closing contingency. You need to be sure to put that on your calendar about 7 or 8 business days prior to closing date, and be sure to circle back around with your buyer to make sure that they do have or feel comfortable enough that they're going to be able to satisfy the financing contingency. If they don't feel comfortable, then they need to have some conversations with their lender, some strong conversations with the lender, to make sure the lender is going to be able to get this loan done or not. Because once you get within that 5 business day period, earnest money has gone hard and the loan is no longer contingent on financing. The other thing that we see quite a bit is what happens if the closing date moves. Does this date automatically move with it? It's questionable. It's questionable because it depends a lot on how you amend the contract. Because the date is set forth in paragraph 7. So if you go in and do an addendum and state that the date of closing set forth in paragraph 7 is hereby amended to now read August 15th or August 18th or whatever, now paragraph 7 is matching what you're doing, which is moving the closing date. So yes, it would expire 5 business days prior to the date put in paragraph 7, which has now been moved. If you just do an addendum that says closing is now September 1st, it's arguably that it didn't move it because it's not talking about amending paragraph 7. My point being is when you do an amendment to the contract on this, is that you state in the addendum paragraph, the date in paragraph 7 for closing is hereby changed from blank to blank, and all contingency dates move forward with it. And so if you state that clear, there's no argument about it that that new date moves along as well. A lot of sellers will not go for that because they're like, if we're going to extend this contract for 30 days, then you're going to lose this extension here. I mean, this contingency here. So So just be careful with that. All right. Letter A is something we spent some time on recently. We used to just have conventional FHA and VA. We went ahead and added USDA, state housing conventional, seller, cash, and others, because if you are needing a quick sell and the buyer is moving in and is doing a USDA loan and they're telling you they're going to close in 10 days, we know that's not going to happen. USDA loans don't close in 10 days. Heck, conventional loans aren't closing in 30 days right now. It's, I will tell you about, I've talked about 10 or 15 different lenders over the last couple of weeks, and they're telling us they need y'all to start doing 45-day closes. Right now, one of my friends, Trey Baker over at Gill Mortgage, says his phone's ringing off the hook so bad with refinances that he can't even call his friends back to tell them what the rates are to see if they want to refinance. They just have so much going on. And every lender, I will tell you this, all the lenders I'm talking to say, we prioritize purchase. We don't prioritize refinances. We're prioritizing what the real estate agents do. So they're putting you guys at the top. But the point being is you need more time to get closings done. Under Section A here, by adding these additional times, it helps your seller look at and see whether these time frames truly are going to happen or not. So that's going to help them out a lot. Under the next section, buyers and buyer's agents will immediately notify seller or seller's agent if the financing type changes. In the old contract, it automatically voided the contract. If you went from, say, conventional to VA or VA to conventional, the contract was automatically voided because you changed financing type. But now it says, because we did a good job on this, in my opinion, if the change in financing modifies the terms of the contract, so the seller will then have the option of agreeing with the change or voiding the contract. And essentially what we're saying there is, if I go to VA to conventional, there's no change in the terms of the contract. I'm still making my closing date. You're not having to pay any fees. However, if I go from conventional to VA, that could change the terms of the contract, because now you may have to pay my termite letter. And so that's when you have the right as the seller to say, I didn't agree to pay that $100, so therefore I'm voiding the contract. I don't see this happening often, but you do have the right to do that. If the seller doesn't void the contract and continues to act in a manner that leads the buyer and the lender and the agents to believe that the contract's still going through, the seller can't show up the day before contract closing 3 or 4 weeks later and go, oh, you know what? They changed closing type, so now I'm going to cancel it, because there's been detrimental reliance. So be sure, if your seller wants to void the contract, that they need to do it very close or contemporaneous with the change, not wait to the last minute and try to use that as a reason. All right. If buyer utilizes FHA or VA financing, lender required addendum is going to be signed. That's the mandatory clause addendums that we talked about. Y'all already do that already, so that's really not much to talk about there. Let's see. Application for financing is letter B. If lender financing is used, this is something that's overlooked quite a bit as well. Buyer has 5 business days from the date of contract acceptance to apply for financing from lender of their choice. 5 business days. I actually saw somebody invoke this the other day because the buyer did not apply for the loan within the 5 days. They got a better offer. And so because they did not do so, seller terminated the transaction, said they didn't comply with the financing provisions. So be sure that your client is applying for the loan within 5 business days. Now, what does applying for the loan mean? It means advancing funds required by the lender, providing lender's identity to the seller and seller's broker. It basically means doing aliens. If you remember, we talked about aliens 2 core classes ago. It was providing the lender the address, the loan amount, and your name, your address, social security number, certain things you had to provide that made up that acronym alien. So be sure that your client's providing all of that. All right. B1, should you fail to apply, buyer doesn't apply, buyer will be in default. Seller has the option of voiding the contract with earnest money being released to seller. Not back to the buyer, to the seller. So be sure you all understand that, and you go over that provision with your client to make sure that they do apply for the loan. Now, if the loan is denied and it's subject to financing, the contract will be voided and earnest money will be released. That's when it goes back to the buyer. Now, if the loan is rejected, the buyers or the agents have to give written notice to the seller or seller's agent, and the seller does have the option of either continuing with the contract and letting you apply for another lender or voiding the contract. If they void the contract, money goes back to the buyer. Under paragraph section 3, if you elect to if the buyer makes any changes to their financial condition that negatively affects their ability to buy the house, then it's a default and the seller gets the money. I'll give you an example. I had a closing one time where we were literally at the closing table. The buyer came in and said, I've left messages for everybody. I bought a new Escalade last night and my car won't fit in the garage. So I wonder if the builder could jack up the garage. Now, I don't know what was sillier, the fact that they were buying a $100,000 car when they were trying to buy a $120,000 house, or the fact they thought that the lender the builder could just jack up the garage and stick a couple extra boards underneath it, I guess. So needless to say, that loan did not close, and that is a default by the buyer. Paragraph 4, buyer gives permission to lender to disclose any allowable pertinent information concerning the loan to the attorney representing buyer or seller. Yeah, it says that, but a lot of lenders just aren't going to do it. It doesn't matter. It's in the contract. We can point that out to lenders all day long. You can call as the buyer, as the listing agent, and say, look, I need to know what's going on, but lenders are going to do what lenders want to do on that. Paragraph 6C, seller financing. If seller financing is included in the financing of the property, the brokers make no representation as to their creditworthiness. This is protection for you. And all of the terms of this financing should be noted in paragraph 18. This is another problem we see quite a bit on seller financing, is that people will just write seller to finance transaction. I have absolutely no idea what that means. What is the interest rate? What's the loan amount? Are we amortizing it over 30 years? Do they have 30 years to pay it? Or is it amortized over 30 years and you're paying it on a balloon note in 5? Are you doing escrows? What is it? So what I would strongly suggest to you is that when you're setting out seller financing terms, is think about, if you were getting a loan, what terms do you want to know? I want to know what my loan amount's going to be, what the interest rate's going to be, how long is my amortization schedule going to be, when's my call date on the loan, whether or not I got to pay, whether or not we're going to escrow for homeowners insurance and taxes, or am I going to pay those outside? Are there any fees that I'm going to pay for the preparation of the documents, for the note, the mortgage? Am I paying any origination fee? Whatever it may be, be sure that you're putting all of that information down in paragraph 18. Under cash transactions, paragraph D, if buyer agrees to provide, it says buyer agrees to provide seller and seller broker within 5 business days, again, we're going that 5 business day rule of acceptance of contract, written verification of availability of funds from the source of those funds. So if your client's buying a house and they tell you they're paying cash, within 5 business days, they have to provide evidence to the listing agent telling them how they're planning on using the cash. Now, I'll give you easy examples. If you have the money sitting in the bank, they can simply go to their bank and ask the bank officer to write a letter saying that they have reviewed the contract and see that you're paying $200,000 cash for this property, and they are stating as of August 12th that you have enough money in your bank account to cover it. That's the easy way to do it. Another way to do it is provide a copy of your bank statement. Not a lot of people want to do that, but you can provide a copy of the bank statement showing that. If the money's coming out of a stock transaction or a 401k, cash out, something of that nature, they can simply go ask that provider to provide a letter. If mom and dad are providing the cash, get mom and dad to write the letter saying we're providing the cash, which probably adds another layer. We need to know where mom and dad are getting the cash so they have it as well. So be sure that you are complying with that, because if you fail to comply with this, the seller has the option of voiding the contract. Again, in today's market, other offers might still be coming in that might be better than your offer, so you don't want to give the seller a reason to terminate the contract. Paragraph E is very important. Let's talk about appraisal contingency. Contract is or is not contingent on the appraisal. Keep in mind, the appraisal contingency does not expire. There's no expiration date on that. Financing contingency does. So if my loan has been approved and we're within 3 days of closing, but now the appraisal comes back and the house doesn't appraise, even though I'm within that 5-day time period of the financing contingency, I can terminate because of appraisal contingency. So keep in mind, those two contingencies are completely separate. You may have your house contingent on appraisal, but not contingent on financing. You may have it contingent on financing, but not contingent on appraisal. So they are 2 separate contingencies. And a lot of people think they get all tied together and say, well, they can't cancel under the appraisal because that has to do with the loan, and the loan has a 5-day rule. No, there's no 5-day rule for appraisal. If the property does not appraise and it is contingent on appraisal, the buyer has 3 business days after notification to either go ahead and consummate the sale, which means go ahead and close without regard to the price, just they pay the difference. Where you might see that is house is under contract for $200, it appraises at $199. Buyer doesn't care, it's within $1,000, they're just going to pay the difference in the $1,000 of cash on the transaction, so the lender doesn't mind, it's not a problem. So they can do that. Or they can attempt to renegotiate the contract. That happens where the house is $200,000 and the appraisal comes in because we have a certain guy for the VA who does appraisals and he gives us real crappy appraisals. So you got a VA appraisal out there, $200,000 sales price, and now it comes in at $189, $11,000 difference. So now we are back into negotiation, and Matt smiled because he knows who I'm talking about there. I didn't say names. Attempt to renegotiate the contract. The reality is, once that happens and we start trying to renegotiate the contract, the reality of it is we don't even have a contract at this point. So my house, the contract's $200,000, appraisal comes in at $189. I go to Matt, the seller, and say, Matt, I'm not buying his house. It appraised at $189. I'll buy it at $189. Now at that point, we've opened up negotiations. The reality of it is, at this point, we're done. There's no contract. We have put in the contract that after 3 business day period, the parties are unable to reach an agreement and renegotiate, then either party can terminate. The reality of it is, I got to come to an agreement with Matt now because I'm not willing to pay $200. And he's like, it's appraised at $189. I've offered to pay him $189. If he says no, my offer is basically, is not valid anymore. So all I got to do is just sit there for 3 days and wait. I just keep saying no, 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 no. Even if it came back now at $189 and said, okay, I'll sell it to you at $189. No, I still think the appraisal is too high. So there's just no contract at that point. But we put this in there to try to keep parties together. That's for y'all's information. Paragraph F, seller gives permission to the closing attorney to get the payoff.
Gary, let me interrupt you. I'll give you a chance to take your breath. And we're going to ask 2 questions in review of paragraph 6 real quickly. Kathleen, if you'll just put up question number 5, and let's get a poll from our audience on that one. Question is, as a buyer's agent, according to the CCRA contract, do I have to notify the seller's agent if my buyer's financing type changes? Should be pretty straightforward. Gary went over that. And give you another 5-10 seconds to hit an answer. And show us the answers if we could get that. Yes, 100%. I was hoping we'd get 100% today. Great job. And then Becky's going to share a second question with us on paragraph 6. Kathleen, if you'll put up the second question on paragraph 6.
Okay. Yep, we got it up. So, according to paragraph 6, when is the seller required to pay certain VA non-allowable expenses? And in this case, we're speaking about the termite inspection, or CL 100. Are they required to pay for that before the inspection, upon the completion of the inspection, or upon closing? So, John, is that enough time? Oh, there we go. So we have the majority of the people, very good, saying upon closing. And in practice, sometimes I think because termite inspections often have to be paid by the company ahead of time, it seems like the seller should be paying it then. However, it is a buyer's expense until closing, at which point the VA says the veteran cannot pay that, so it is listed as a seller expense. So very good.
Good, thanks, Beck.
Give me green screen sharing ability back. There we go. All right. So let's move on to paragraph 7. We're an hour into the class. Don't fret. The first 9 paragraphs are where we spend the most time. The rest of it is not as detailed that we have to go through. All right. Paragraph 7, conveyance date of closing. This says that you're going to convey title. Your seller is going to convey title and marketable title. And that's something you'll need to be very careful of. Marketable title essentially means title that a reasonably prudent purchaser, knowing all the facts, would still purchase the property. That is different from insurable title. Insurable title says there may be a title issue, but the title insurance company is willing to insure over that matter. And so you need to make sure that your clients understand they have to convey marketable title. Now, A buyer may sometimes be willing to accept insurable title on certain issues, but this is for lawyers, and this is where lawyers need to get involved. So if you know that your seller's got some title problem and they say, hey, when I bought the house, we had this issue with title, go ahead and get with a closing attorney so that you can find out what needs to be done. Because sometimes we need to scratch out marketable title and just offer insurable title. Tax sales are a prime example. Listen to me very carefully, please. Do not list a property that somebody bought at tax sale before you talk to an attorney. That's simple. Do not list a piece of property that somebody's just bought from tax sale without talking to an attorney. They do not have marketable title. They do not even have insurable title. They have no title. They have a quit claim deed. And so when you have your client sell property and the seller agrees to convey marketable title, you just made that seller agree to correct that tax sale issue, which means a quiet title action, which can be thousands of dollars. So do not list property and try to sell it until you talk to a good closing attorney as to what kind of contract you need to be offering or accepting. Okay. Same thing if you're buying tax sale property. Make sure that your buyer gets with an attorney to understand all the risks that are involved, and they are many. Now, the contract requires a general warranty deed. I'm not going to get into this as all legalese, but there are certain warranties in the deed, with warranty of good title, warranties of enjoyment, things of that nature. And basically what a general warranty deed is saying is that we warrant for all time that you have that you can enjoy the property and use it for these needs. A special warranty deed is different from a general warranty deed, and the special warranty deed simply says that the seller only warrant during the period that I had it, that I didn't mess with any of the warranties. Back in the day, that was a problem, but as long as your buyer is getting title insurance, the difference between special warranty deed or a general warranty deed is not a problem because title insurance covers all of that for you anyway. So we're good to go there. Deed will be prepared in the names of blank. Be sure that you please put the right names here. And this seems funny that you would have to, I should even have to mention this, but you need to make sure that if spouses or partners or whatever are buying the property or kids, make sure their names are going here because the lender is going to want to make sure that the names are proper here as well. Deed is going to be held in trust by the closing attorney until sales proceeds have been dispersed. We define closing in this transaction as disbursement. And so this allows for the seller to come to transaction beforehand, sign the deed, we hold the deed, and then your buyer comes and signs at a later time. This is happening every day right now because most attorneys, including this firm, we are not putting buyers and sellers together in the same closing room because of COVID concerns. So we are scheduling the sellers at different times than we are scheduling the buyers. So a seller can come days before the buyer and sign the deed, and we just hold that in trust. Now, one thing you need to really understand is a seller cannot come after the buyer when the buyer is taking out a loan and giving a mortgage to a lender and sign the deed. The deed cannot be dated after the mortgage. Simple reason is you can't mortgage property you don't own. So the seller has to have, the deed has to be dated the same day or a day before, or before the actual mortgage is signed. So we have people a lot of times saying, well, the buyer wants to come on Monday and the seller will just come on Tuesday or Wednesday. No, it can't work that way. The seller has to sign either the same day or before the mortgage is signed. All right. We have a closing date here. Again, we've talked about this. Please do not do 10-day closing days right now. I read an article on Hotwire, I think it was Hotwire, whatever it was called, that said September is the new May when it comes to real estate. So they're expecting May-type numbers for September. That usually doesn't happen. So I expect September and August and September is going to be crazy. It's just like a summer month. And we expect October to even continue over and be as busy as well. So you just can't get closings done that quick. Under 7A, seller's obligation to vacate the property is either going to be 24 hours, 48 hours, or in accordance with the attached agreement, or at closing. This is important because a lot of sellers right now just don't want to pack up until they know this is going to actually happen. So be very careful that you actually are discussing this with your client, deciding what your client wants. The property is supposed to be free of debris and in a clean condition. This is one of those legalities versus realities. The legality of it is if your seller doesn't clean the property and leave it in a good condition, they're in default. But the reality of it is, what's the buyer going to sue them for? They're going to sue them because they didn't vacuum the house, It's just a feel-good provision, hopefully making people realize they need to do certain things, but it's very hard to enforce that. Letter B, and when they do enforce it, basically it means the real estate agent pays somebody to do it. Let's just be honest. That's every time I've had this come up in a closing, somebody's grass wasn't cut or somebody's house wasn't cleaned. Unfortunately, it seems that the real estate agent says, fine, I'll pay my person to go out and cut the grass. I hate that. That's what happens.
Gary, it's a good idea then to tell buyers that the house is as clean as it's going to get when they see it. And if they want it to be cleaner, then to put a professional cleaning in the contract, you think?
Absolutely. Same thing with yard. Absolutely. Good point. All right, letter B. If buyer, this is another one of these that had caused a lot of arguments at the contract committee. 7B. If buyer has been provided with a written loan commitment without additional conditions or a cash transaction, and buyer's met all the terms and the conditions of paragraph 6D, but is not closed within the stipulated time of the contract, both parties agree to extend the contract for a period not to exceed 5 business days from the original closing date. So it's not 5 days, it's 5 business days. And this automatic extensions in here, a lot of people didn't want it. A lot of people wanted it longer, but we still have it. So you need to understand it. Now, in order to invoke this, you have to provide written loan commitment without additional conditions. That's kind of hard to get in a lot of cases. Basically, where this is used effectively is in situations we were in August and in July, where there's either not an available closing time, person, is supposed to close on Friday, and the closing attorney's already booked up, and so they can't close it till Monday, or some of these crazy things that have popped up during COVID. It's out of everybody's control. Something's happened, whatever it is, then the 5 days. So be sure you understand how this rule works. It is buyer has provided written loan commitment. And this is the part that a lot of buyers don't do. And a lot of sellers say, well, we never got the loan commitment. They don't have a loan commitment as far as we understand, so they don't get the 5 days. It is not automatic. You have to have provided the written loan commitment. Paragraph 8, buyer's right to inspect and re-inspect. This is going to go along with 8, 9, and 10. I'm going to spend some time here, and then we're going to fly through the rest of it here. Paragraph 8, what we've done here is it says that the buyer has the right to inspect the property and do an examination, inspections, and tests of the property they want to do. Now, we defined an inspector as a person or company licensed and certified where required by law with specific professional expertise and knowledge in property inspection of the item in which being inspected. Yes, that's what an inspector is. But the reality of it is a lot of the things that we inspect in our house, there's no such thing as an inspector. So for instance, if I'm going into your house and I've noticed that you have a cat, I'm not sure there's a cat urine inspector. I mean, I think I can go look myself at the carpets and see whether I find cat urine stains and smell it myself and decide, yeah, the carpet needs to be replaced because it smells like urine or smells like vinegar. So the term inspector is used there for this purpose. If you're going to submit a request for CL 100 repairs, it needs to come from a licensed inspector. That's even required by law anyway. Doesn't need to come from your dad who's a handyman. So that's why we put the term inspectors in there, to make sure that we got the actual people that need to be doing the inspections. The seller has to make the property available for all inspections and must have all utilities operational. That's the thing that sellers aren't doing a lot of times. They've moved out, they turned off the power, whatever, turn off the water. They're not supposed to do that. Utilities all have to be operational, because how can you inspect to make sure there's proper water pressure, there's not problems with the water if the water's turned off? It also has to be on for any re-inspections, appraisals, and final walkthroughs. And that's something we talked about in the video that John mentioned earlier that we did. We talked about that in detail. So y'all might want to watch that video. It's pretty good. All right, let's see. And then the buyer has a right to re-inspect and make sure that all repairs that requested to be done have in fact been done. And so they have a right to perform a walkthrough prior to closing and confirm that. Paragraph 9 and 10 are going to be the most important parts of this contract and for me for this discussion. So what I'm going to do is I'm going to start with paragraph 10. So we're going to skip 9. We'll come back to 10 because I think it's easier for me to explain this under 10 and then come back into paragraph 9.
Gary,
so let's talk about, yes, sir.
Gary, what about, I think we did this last time. It was helpful. Can we skip to paragraph 29 and have you define what a business day is first? and then
Sure.
come back to paragraph 10?
Yep.